Good evening, everyone. I have to say that on behalf of April and Jayne and their legal team, Carol and Ken, certainly we were hoping to be addressing everyone about the decision under more joyous circumstances. We are not. We are disappointed with the decision, but we remain determined. And I can say absolutely 100% that we intend to appeal our case to the United States Supreme Court. And we believe that this issue has to be resolved by the Supreme Court one way or the other, and whether it is our case or perhaps another case from the Sixth Circuit, the United States Supreme Court needs to be the court that makes the decision for all 50 states in the country at this point so that we can have marriage equality everywhere in the United States of America. And as always, we are very, very proud to be standing up here with our clients, April and Jayne. We are so proud to represent them, and we remain proud to continue representing them. And we said from the very beginning that we would be representing them for as long as their case took and as far as their case went. And obviously, our case continues on now. So with that, I'm going to have April and Jayne make a brief statement, and then for all of your in-depth legal questions, Carol Stanier and Ken Mogul will be here, and they can answer any questions that you have about legal proceedings and where the case goes from here. And thank you all for coming tonight.
Thank you, everybody, for being here. Jayne and I would like to thank everybody for their support. The decision that we got today was, a little bit on the disappointing side, but we stand before you to tell you that we are going to continue to fight. We're going to fight for the rights of our children, and we will do whatever it takes to ensure that our children have rights and here in Michigan, and children like ours all over the United States now.
Thanks, guys. Just to reiterate, yes, we are going to continue the fight. We were prepared, kind of a little bit either way, how the decision was going to go. Of course, we were, hoping it would go a little bit more our way, but that didn't happen, and we're okay with that. We're going to continue the fight because we said we would, and our attorneys said we would, and they will stand by us, and they are. And you guys are behind us, and we greatly appreciate that. You can't imagine how happy we are to see all these faces out here that came out to support us. And I know there are many people out there who are in. Thanks. There are so many people in Ann Arbor and Lansing and all the other places that I'm sure are gathering and are behind us also, saying their little prayers and knowing that this is going to go forward. We're so proud to represent every single one of you and all your families, just like our families. Thank you.
Carol Stanier, we will be filing a petition for cert probably within the next 2 weeks. After that, the state has the opportunity to respond. That takes another 30 days. And after that, this case and the other cases would be calendared by the court. So we do expect that if the court decides that they want to take a case, that it will be decided this term. So, unless there's any questions?
Carol, give us your comments about the language in the ruling about how two federal judges cannot decide this kind of issue. And if you comment also on anything that their reasoning that may have surprised you.
It's a 60-something page opinion, so I don't want to, comment too much about the analysis. He decided on the basis of democracy, which we anticipated. He decided on the basis of Baker, which is a Supreme Court decision from before, and we'll be ready to respond to those in the petition.
explain the legal implications why this case could be the case that the U.S. Supreme Court ultimately will use to decide this issue once and for all?
Well, the most important thing is that there's now a conflict amongst the circuits. There wasn't a conflict before when the other petitions for cert were up before the court. Secondly, they could take any one of these cases. They could take none of the cases. Our case has a trial record. We are the only case with a trial record, so that might be appealing to the court, but we just don't know what they're going to do.
So could this potentially speed up the decision to make gay marriage illegal?
Well, if the court certainly takes a case, it'll result in a ruling for the country, so all 50 states. So we wouldn't be going piecemeal by piecemeal and waiting for cert denials. You'd get a ruling for 50 states.
So couldn't in a roundabout way this be beneficial?
It could have sped things up.
So the Michigan case could set the precedent for the nation?
It could. Anybody else?
When is the soonest you can find out whether this case will be taken up by it?
Probably not sooner than January of 2015. So the court has to consider all the parties' pleadings, and then they put it on the first calendar after everything's submitted.
It would be the first time that they might hear arguments with January 20th.
They wouldn't hear arguments then. That's when they would calendar the case and make a decision about whether or not they're going to grant the petition for certiorari. So they decide that they're going to decide it at that point.
Does anything change in the status of the marriages, the 300 or so that occurred in that window right after Judge Friedman's ruling?
It's my understanding that those marriages are intact, that they have not been affected at all. None can go forward, new marriages, at least until the case is decided now.
But they're not getting benefits under Governor Snyder's interpretation. So if you would win in the Supreme Court,
That would solve all of the marriages. Yes. There would be no basis to deprive any couple of benefits as a result of marriage.
When you say that the marriages are intact, I guess that's on.
They're valid. The marriages are valid. The 300 plus marriages are valid.
Is there any rights that they get under those, if they're valid, the ones who are valid? I know they're not in the state, but is there anything that any laws that they're?
As a result of the decision, I mean, we have to sort all that out.
This decision doesn't change anything about those marriages. And sorry about that. But this decision doesn't change anything about those marriages. They were valid when performed, and they're also the subject of a separate case that's being litigated in federal court in Detroit now as well. But there's something about the decision that the Sixth Circuit issued today that, as I see it, should affect what we believe is the validity of those marriages.
Unless there's any other questions? Okay.
Could Heather and Jayne just talk a little bit about where they were when they heard
Heather?
this?
April?
Actually, the funny thing is I found out via phone call while I was in the car picking up our babysitter, because Jayne and I were actually supposed to be car shopping tonight. So, we actually didn't speak for about, I think, 30 minutes after we found out about the decision separately. So Jayne was home with the kids, and I was up picking up the babysitter with the dog. The new dog, yes, the new dog.
It sounds like you're saying you were prepared either way, and yet there was this string of federal court rulings on your side. So were you still thinking about, were you leaning that way, that might be the outcome in the Sixth Circuit?
You know, we were hopeful. We were hopeful that, the decision would come back in our favor. But we were also prepared if it didn't. And so we prepared ourselves for a longer fight, for waiting a little bit longer for marriage rights and, our kids to have rights here in Michigan. So it made us a little bit more hopeful, but didn't change, how we perceived everything, and that the fact that this could have happened the way it did. And so we're going to continue to fight.
Jayne, what do you tell the kids when it starts with the adoption case? What do you say to them?
Our daughter seems to be the only one that really is following what we're doing. And every once in a while, when we get dressed up to go out, she asks if we're getting married today. And we continue to tell her no, not today. And we discuss, we answer their questions. They're few and far between. Usually, most of them come around this time when there's media. But other than that, we just try to live our lives normally, and we try to give them, the support that they need. We don't shelter them from what we're doing, but they're very young, being, 2 5-year-olds and a 4-year-old. So, I don't think they realize the magnitude of what we're doing.
One more for Dana. Mike, even if the Supreme Court were to rule against you, talk a bit about another statewide petition drive and what you think the result would be, and would that solve the issue anyway?
Right. Well, I mean, that's for, people who are advocates and who have a lot of fundraising ability. Obviously, we know that that's a very expensive proposition to put something on the ballot. But, I mean, we remain extremely hopeful and confident that the Supreme Court will resolve this issue in favor of our clients and in favor of all plaintiffs in similar lawsuits, and that there will be no need, we hope, for a referendum here or any place else in the country when this case is disposed of finally, or another case, in the Sixth Circuit. My understanding is that since the Fifth Circuit, which also had a case, a couple cases now that are pending in Texas and Louisiana, I don't even know if they've scheduled argument yet. So they're so far behind that a case from the Fifth Circuit or any of the remaining circuits that have yet to rule can't possibly make it to the Supreme Court in time for the end of this term. So if the Supreme Court is going to rule on this issue this term, it has to be one of the cases from the Sixth Circuit. And so obviously we're extremely hopeful that they will take one of the Sixth Circuit cases so that we can finally have a final answer to this by the end of June of 2015, which is the latest that decisions come in from the United States Supreme Court. But in answer again to your question, Roger, we're obviously very much hoping that a ballot initiative or a referendum will not be necessary here or anyplace else.
There's a total of 6 cases from the Sixth Circuit. Ours was one of the 6.
4 states.
4 states. Our case was the only one from Michigan. There were 2 from Ohio, 2 from Kentucky, and 1 from Tennessee. One of the Kentucky cases was also a marriage case, like ours. The other 4 cases were marriage recognition cases involving couples who had been lawfully married in other states, returned to their home states, and their home states would not recognize their marriages.
Thank you very much for coming.
Thank you.